Good morning. Now that you're in Mombasa, let me acknowledge the Mwenyekiti and the CEO of ICS, my fellow colleagues, CSS, and all that have attended this very important conference that is seeking to address the question of ethical leadership and good governance, restoring trust, renewing morals, and securing the future. Let me also indicate that it is a great privilege for me and an honor to be back with colleagues whom I have worked in various forums before, and to see that you're continuing the good work of advancing the cause of the CS fraternity. As CS has indicated, I am a messenger in many ways, and so I will deliver the message on behalf of the one who sent me. Then after the message, we can engage on this subject. And true, the topic which the Honorable the Attorney General, Honorable Dorcas Odro, was asked to speak to during this conference is on restoring public trust by upholding the Constitution and the rule of law. And so before I get to the speech, I think we can make certain assumptions. As FCS has already indicated, do we have trust or don't we have trust? Is there a trust deficit or not? And if we agree that there is a trust deficit, then we need to address how can we restore that trust. And especially focusing on the trajectory of upholding the Constitution, the primary law of our country, and the rule of law. This then is the statement of the Honorable the Attorney General with regards to this subject. Distinguished guests, ladies and gentlemen. She says, one, she apologizes for not having been able to be with you today. She had assignments outside of the country. However, were she to be here, she indicates that it would have been both a distinct honor and privilege to stand before you this day at this significant occasion to address you on the critical issue of restoring public trust through our unwavering commitment to upholding the Constitution and the rule of law. She wishes also to express her appreciation to the Institute of Certified Secretaries for organizing this forum, and to all of you, the ICS fraternity, for the vital role you continue to play in promoting sound governance, transparency, institutional compliance in our country. Ladies and gentlemen, the theme of this conference is apt as we reflect on 15 years of Kenya's journey towards a constitutional order inspired by the aspirations of her people, as ingrained in the words of the preamble, "We the people of Kenya." Since the year 2010, Kenya's constitutional order combined the heroic struggle of our past to bring freedom and justice to our land, and the desire for future generations for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. Respecting the sovereignty of Kenya's people to be governed in accordance with the Constitution, the implementation therefore has remained a key priority for successive governments. The Constitution is a first and definitive step upon which constitutionalism, or the legitimacy of government actions, is hinged. However, to have a constitution alone does not secure constitutionalism. Tremendous strides have been made and achieved in building the institutions envisaged to promote, protect, and preserve the Constitution. This ensures that power resides in and is exercised by independent and interdependent organs. The distribution of power or mandate amongst the different organs creates the necessary checks and balances intended to serve the people. The mandate of the Office of the Attorney General and the Department of Justice requires a steadfast vigilance in protecting the principles enshrined in our Constitution. This means safeguarding the rights and freedoms of every individual, preserving the balance of powers, and holding institutions accountable to the people they serve. It is through this fidelity to the rule of law that we build the foundation of public trust. Trust that is essential for the legitimacy and strength of our democracy. Ladies and gentlemen, to this end, my office has embarked on a process to bring to fruition the necessary legislative reform measures that catalyze public confidence in all processes of government. These include the Anti-Corruption Laws Amendment Bill, the Public Participation Bill, the Whistleblowers Protection Bill, and the Conflict of Interests Bill. As we focus on the role of the duty bearers, being the state and its agencies, it is also essential that constitutionalism and the rule of law are viewed from the prism of an aware, empowered, and engaged citizenry. These legislations is intended to give meaning to the voices of the ordinary citizenry in the governance of their affairs in accordance with the Constitution. And here she's making reference to the Anti-Corruption Laws Amendment Bill, the Public Participation Bill, and the Whistleblowers Protection Bill, and the Conflict of Interests Bill. The political pillar of Vision 2030 is a democratic political system that is issue-based, people-centered, result-oriented, and accountable to the public. Of particular note in the proposed legislation is a strengthened legal framework for combating corruption, which is a major taint on individual and institutional fidelity to the Constitution. The safety and non-victimization for reporting malpractices, and the regulation of conflict of interests. These are pivotal in promotion of good governance, upholding constitutionalism and the rule of law, as they create an intersection between the actions of public officers and the public voice. The generic framework that establishes standardized guidelines for public participation across all levels of government to ensure consistency and adherence to best practices will increase the quality and legitimacy of decisions made through consultations and foster inclusivity and build trust in the process. The commitment of government to promote, protect, and preserve these ideals has further been acknowledged with the designation of a State Department for Justice, Human Rights, and Constitutional Affairs, which is a recent development. Ladies and gentlemen, the government has also taken concrete steps to strengthen the independence of the three arms of government, the legislature, executive, and the judiciary. I highlight a few that have direct bearing on the theme of this conference. Firstly, in this transformative agenda is the operationalization in the financial year 2022-2023 budget of the Judiciary Fund, established under Article 173 of the Constitution. It is acknowledged that financial autonomy of the judiciary as an institution complements the immunity and independence of the judges, thus guaranteeing impartial dispensation of justice and maintaining the supremacy of the Constitution. The services of the judiciary will be expected to extend and reach and enhance access across the country, thus bringing courts to the communities. The citizen-centric approach will not only address access, but also ensure that the service is available and affordable. Secondly, the National Police Service 2023-2027 Strategic Plan leverages government's commitment to the operational and financial autonomy of the police service as a critical enabler of effective policing. This intervention will create a people-centric, service-driven public order through a modern, efficient, and responsive police service. These reforms are expected to create a policing approach defined by adherence to due process and the rule of law, fostering excellent relations with communities and inspiring trust among the citizens. Thirdly, the constitutional principles of transparency, accountability, non-discrimination, prudent utilization of public resources, and public participation in the decision-making process will further be promoted through AI-driven solutions. Kenya's National AI Strategy 2025-2030 is positioned to deliver a citizen-centric service by making government services more transparent, equitable, and efficient. With an increasingly informed and technologically engaged population, government is poised to leverage the relative advantages of AI, a product of the fourth industrial age, to enhance public trust in its services. The more government is understood by the greater populace, the more meaningfully can the citizen critique governmental action. The more informed the participation of the citizen, the more responsive and sensitive should the government action become. And I would pause here to acknowledge the previous presenter, Dr. Kahora, for his fair, informed, and balanced critique of laws and actions. That is what this strategy seeks to provide. The adoption of AI enables citizen queries, predictive analytics, e-government portals are just but some of the wide array of solutions which will make services available at the fingertip. The strategy also has the potential to address the negative impact of misinformation and digital manipulation. As an example, my office has a robust strategy for setting up an online participation portal, mobile applications, and SMS platforms to facilitate broader citizen engagement, especially in rural areas. And here again, I pause to mention that the Office of the Attorney General now has a presence in not less than 36 counties, aiming to be all over the country in the next financial year. This use of technology will improve accessibility and reduce the logistical challenges of in-person meetings. Training government officials and civil society to engage participation, to manage participation processes effectively, alongside large-scale civic education campaigns to inform citizens about their rights and responsibilities. To monitor the impact of the strategy, we will develop a feedback mechanism to track public input and demonstrate how citizen contributions influence policy decisions, thereby promoting trust and transparency. Fourthly, all state actors are expected to act in accordance with the Constitution and the law. The rule of law imperative that places every individual under the law is furthered by the establishment of constitutional structures for government. The periodic elections for elective offices creates a cyclic process whereby the citizen express their choice of government. The internal and external mechanism for checks and balances seek to foster free and fair elections where the will of the people in a democratic government is upheld and respected. Despite the institutional challenges, these elections have produced free, fair, and credible outcomes at the various levels of elective positions at the national and county governments. The institutional independence of the Independent Electoral and Boundaries Commission and the adjudicatory independence of the judiciary has ensured that the processes and disputes are handled by autonomous institutions. Whilst much more should be done to improve the electoral processes, the constitutional framework holds a promise for greater public trust. The reconstitution of the IEBC will further enable the institution discharge its mandate as an important part of the expression of the democratic design in the electoral process. Ladies and gentlemen, public trust is not granted. It must be earned through actions that reflect integrity, fairness, and a commitment to justice. Restoring trust requires us to tackle corruption with unrelenting resolve. to ensure equality before the law and empower citizens with confidence that their voices matter and their grievances will be addressed. In this shared responsibility, certified public secretaries play the vital role as key advisors and compliance officers within both public, private, and civil society sectors. You ensure that decisions are lawful, records are properly maintained, processes are followed, and accountability structures are respected. In essence, you operationalize the rule of law within institutional frameworks. I therefore urge you, as professionals and patriots, to continue being agents of integrity, legality, and ethical governance. Let your actions reinforce confidence in our systems. And in fulfilling these duties, the Office of the Attorney General and State Department for Justice, Human Rights, and Constitutional Affairs pledges to continue being a beacon of transparency, ethical governance, and unwavering dedication to the values that unite us as a nation. Together, let us reaffirm the promise of our Constitution and the enduring power of the rule of law to guide us towards a future of trust and prosperity. Finally, let us therefore move forward, united in purpose and committed to making Kenya a model of constitutionalism and respect for the rule of law. Thank you.
Thank you very, very much. Let's appreciate our speaker once again. Thank you very much. Yes, maybe you can have a seat, and we'll field some questions and or comments. I hope you are internalizing those remarks that have been made by our esteemed guest speaker on restoration of public trust by virtue of upholding the Constitution and the rule of law. He's talked about the legislative framework that the Department of Justice or the Attorney General's office is looking into and has put out, some of which I think are in the stage of public participation, including the public participation bill. Maybe you can talk more about that. You talked about the strengthening of the arms of government, which I think is very critical, and Kenyans indeed are watching to ensure that there can be a strengthening and not a weakening of the same. We need robust institutions which outlive the individuals that hold those offices. I liked the part about the use of technology and including the AI strategy as well. That was, it's good. It's quite informative, I must say, and I think it would be nice to hear a bit more about that. Like what exactly does it entail? I think the citizenry wishes to know access to government services through online portals and all, and how robust are these mechanisms? How safe and efficient are they? Even from a security perspective, and also from a cost perspective. That's me being cheeky on that one. And then you talked about the electoral processes. Yes, that's a very critical thing. I know. Well, I guess Kenya, we're all about elections, aren't we? From one election to the next, even in the 5 years, we don't say there's a break. It continues, and seems to get just more intense as the years progress. And then I like that when you indicated that public trust must be earned, which is very critical, and that there is shared responsibility. So as the government does its part, we as a citizenry also have to be responsible. With all rights come responsibilities. So I like that you brought out that call that we need to also do our part, and especially as this a distinguished profession where we interact a lot with, we are the governance profession. So we interact a lot with documentation, with institutions of government and others, and we're supposed to maintain the highest standards of integrity and ethics and governance. So, indeed, as the Honorable Attorney General has indicated, we need to unite in this purpose of making Kenya a greater country in terms of governance. Yeah, so that was just a quick summary on my part. Thank you very much once again. Let's appreciate him once again. I'll be happy to take, we can take a couple of questions and or comments. This one needs it's a bit light here. Okay. Yes, let's have an interactive session here and see, let's get some thoughts going on the remarks that have been made by CS, well, by the messenger on behalf of his principal, the Honorable, the Attorney General, Dr. Sudur. Honorable.
I have the mic.
Oh, you're the microphone, yes. And please introduce yourself as you, just for the rest, so that for the rest can also know you. Thank you.
Thank you very much, moderator. I want to appreciate the Honorable Attorney General for what I consider to be a fairly good expose of the issues that are involved in this and what needs to be done. My name is John Omo. I started my career at the Attorney General's office 5 years ago. And I have this feeling that we are trying to force public trust rather than earn it. And I'm quite happy that the Honorable Attorney General is considering legislative reforms that seek to, get issues of governance at the fore of our legal processes a lot more strengthened. But I have this feeling, and somebody commented yesterday that all Kenyans are corrupt, minus what they lack are opportunities for corruption. I have this feeling that we, from a legislative point of view, we are dealing with the effect rather than the cause. You hardly would find legislation for ethical behavior because ethics is something that is cultural. You need to ingrain it in your system. You need to teach it. You need to have it as a culture. I'm particularly concerned that through the legislative reforms that are proposed, we are proposing to increase more governance bureaucracies, especially for public corporations. The public organization is the most overgoverned, if I can use that word, sector in this country. Parastatal in this country has over 15 organizations superintending over it. Over 15. And so that organization is always busy reporting to this, reporting to that, reporting to that. And the CEO or their staff have no time for strategic thinking rather than paper pushing in terms of responses to the various governance organizations. Might there be an opportunity one day at the Attorney General's office, I wish, that we can consolidate our governance systems, especially for public corporations, because we spend a lot of time responding to various, of course the Auditor General is given, but the DCI can come in, the ACC can come in, the Inspector General corporations can come in. There are several others that I may not mention here. So that's my fear, that I've heard you to say you are proposing new legislation in terms of enhancing governance structures. My fear is that there is already an overkill. Might there be room to consolidate rather than do a lot more, more piecemeal rather, legislation in terms of our governance structures. Thank you very much, sir.
Thank you very much, CS John Omo. Very valid points you raised there. Thank you. Our speakers had that. I'll come back to you. Let me take per column. I'll come back to you then. Any from this column? None. On that side, any for now? Okay, then, so let me get back to that side, but now to that lady first. She had gone ahead, then, but then I can take yours after this. That's okay. So the lady first, and then this.
My name is Marianne Thuita. So my question to the Office of the Attorney General is, as the guardian of public interest, how does the office balance what it's meant to do in terms of protecting public interest against government interest? Because recent rulings in the court that have led to the fall of some bills have attested that sometimes what is in the interest of the government is not necessarily in the interest of the people. And secondly, in terms of laws, I would just like to know, without proper laws or amendment of laws to keep up with the times, we can't actually have proper governance structures. So what efforts are being done in the office to ensure that the laws as enacted then are keeping up with the struggle, what is happening now? Because you'll find sometimes there's a bill that has been in existence even before the constitution was, ideally they should have been amended, but there's still things we are grappling with even now that are in court even now.
Thank you, Mary. Yes, to the gentleman, please.
Thank you, AG, for the presentation. Mine is it's just to seek.
Could
whether-
you kindly introduce yourself also so that the speaker can know who you are?
My name is Patrick Tutui. I'm a director of East African Portland Cement. Some time back, Judge Anthony Mrima declared Section 22(2) of the Election Act that requires one to have a degree to vie for governor as unconstitutional. Was there any action taken on that issue by the Attorney General? Or are we going to expect that come 2027, the governors who will vie would probably be anyone at any level?
Thank you, CS
Thank you.
Patrick. Thank you. And the last one I'll take. Okay, we'll take 4, then I'll come back to our next set. Mheshimiwa Ekweturu had his hand up first here. Then we'll come back to another set of questions. Thank you. We'll take those initial 4. Thank you.
Thank you. I wish I could see him. Thank you, Mr. Mwiruri. I had occasion to visit the Sharia House the other day as the chairman of Nyumba Kumi. And I want to confirm I was treated nicely, but I think because of recognition. We in the public sector are subject to the advisories from the Attorney General office. And sometimes these advisories go against the law. And if you actually look at this topic you are given, it's about restoring public trust. I don't know whether ICS knew some of the issues we go through. I know there are about 5 to 7 rulings that have by court against the advisories from the AG. So it puts these public servants in very difficult circumstances. So I was to recommend that maybe restoring that trust starts with the Office of the Attorney General. Thank you.
Thank you very much, Mheshimiwa, for that. Yes, Ngugi, you'll be in a position to kindly take those questions. Thank you.
Thank you very much for the questions. And let me begin with the one by Honorable former Speaker Ekweturu. Now, indeed, it is the case that the Attorney General is a principal legal advisor for government. And in the course of the work of advice, you pointed out 5 or so cases where the advice of the Attorney General would be reversed, or a decision which was made hinged on the advice of the Attorney General is countervailed by the courts. In one sense, what that also speaks to is the independence and interdependence of public institutions. So that whereas the decision may be correct and accurate from the giver, another independent institution may consider the advice otherwise. To every 5 that may have been reversed, you will also agree with me, because you've been in government, that 1,000 other advisories will have passed the muster and will have weighed and made decisions which have withstood the test of time. And so maybe if we focus on first making the public aware of the nature of the work, the kind of advisories that are given, and the fact that they facilitate the movement of the institution of government on a day-to-day basis, then we may allow for the constitutional design of other independent decisions also to question the decisions of the principal legal government advisor. On the question of, from Mary Ann Twitter, this is public interest versus government interest, and bills, amendments of laws. So one, I can begin with the second one. You may be aware that there is in existence a Law Reform Commission, which is tasked with the responsibility of continuously considering all laws in our statute books and updating them. And there has been a long process which has been ongoing since the 2010 Constitution of continuously updating laws, both at the national and county government, and ensuring that they comply with the Constitution. So that is an ongoing work. And of course, since every other day there will be an outdated law, in fact, some of the ones I've pointed out today, that the Anti-Corruption Amendment Bill is seeking to amend some of the outdated provisions in the law to bring them up to best practices and the Constitution. So yes, there is already an institution which is daily handling the question of reform of laws, whether at the national or county level. Coming to public interest versus, if there is such a thing, versus government interest, I think you are pitting an orange against another orange. Because the reality is the public is the government. So there is no distinction between, in essence, it's a notional distinction, but the reality is that the public form government. And therefore there is no occasion for distinguishing what, unless you want to get very loyally, is public interest in the strict sense, and if there was such a thing as government interest independent of the public interest. The office, by its constitutional design, will always uphold its responsibility as a defender of the public interest. There is now established a National Legal Aid Service under the Office of the Attorney General, which is now seeking to be independent and available and present in almost all the counties as a public defender. So when we talk about the indigent, those who cannot approach the courts, there is now a body which will be available within the communities to canvass those issues for them before the courts, funded, of course, by public funds. My good friend, Mr. Omo, yes, as acknowledged by the Attorney General, public trust is not granted, it must be earned. And the legislation which I have pointed out seeks to address some of the bottlenecks that have stood in the way of, for instance, the anti-corruption war. If you look at the bill which is now proposed, it seeks to address the question of timelines. The public has expressed a view that corruption cases are taking too long, and now there is in the bill a proposal to put timelines, strict timelines, within which to determine those cases. Once they are determined, there is also timelines on appeal. So when a matter moves from the magistrate, the appeal timeline in the High Court now will be 3 months max. If it moves to the Court of Appeal, another 6 months. And I think when we come to election laws, we have seen what timelines are produced. We can have very agitated disputes resolved within the timeline that is set in statute or the Constitution. And that level of efficiency is what is being sought to be introduced by some of the proposals for the Anti-Corruption Amendment Bill. In terms of over-regulation and bureaucracy, again, probably you'll be aware of the reform of the parastatal sector, not only dealing with the regulation, but also consolidating the number of state corporations and introducing efficiency in this public sector of state corporations. So yes, there's a journey towards consolidating the efforts of government to regulate that space. And then to the question by Patrick Tutui, of course, some of these amendments are being handled, including in the current process which is ongoing, of bringing on board a commission so that we can have a consolidated review of some of the provisions of the law to enable us to introduce amendments before the next elections.
Thank you very much, CS, for those responses. Let's take one last one, which will be that lady. Since I promised you that I would field your question. Let's have a microphone to her, and then we can come to a close.
Good afternoon, all of you. My name is Edith Lubanga, Data Protection Officer and Legal Officer from the Office of the Auditor General. I have a question that is related to what someone asked. We have a number of laws that have been declared unconstitutional. For example, Section 45 to around 50 of the Elections Act. And it was declared unconstitutional almost 10 years ago, if not more than 10 years ago. What is the role of the Attorney General in ensuring that some of these laws that are declared unconstitutional are amended in order to prevent us having these legal gaps that we currently have that stifle the rights of the Wananchi? Thank you.
Thank you, Edith. I think you can, yes, Edith, you can take that. Yes, that will be our last one.
Thank you, Edith. Again, as I have indicated, there is an institution dedicated to that function of law reform, looking at judicial pronouncements, and embarking on a process of amendment of laws. What, however, does happen is that our process of amendment of laws, and especially in certain subjects, as you'll agree with me, is a public process. It will take time. Amendments are introduced. There's debate around them. And sometimes it may not be as quick as we anticipate those processes to take. However, yes, indeed, all pronouncements that are made by courts that will require intervention of legislation, and I'll give an example which was highlighted by the Attorney General, the Public Participation Bill is a direct response to the litigation around public participation, including all the way up to the Supreme Court, which has now laid the guidelines and principles for public participation. There is now a bill under discussion to bring into effect judge-made law. So yes, there is a continuous process of engaging with what the court is producing, looking at public policy, and then, of course, going through the whole process of legislation.
Okay, thank you very, very much. Shall we appreciate our speaker? Thank you very much. Please just come this way. I want to give you a token. So you have been told that you are the public, aren't you? So you're also the government. Government sitteth in the room. So the Office of the Attorney General defends your interests. You're in good hands. Thank you very much for just demystifying a number of concepts which, maybe media reports that we may see, which are not very clear because we're not able to sort of interrogate them. So thank you for just bringing them, shedding light and giving us some color on some of those aspects, the reforms that have been undertaken, whether it's on electoral laws, on implementing the Constitution, because 15 years later there are still some laws which probably have still not been enacted, but anyway, it's work in progress. At least we're getting there. That's what matters. It's still a fairly young Constitution, at 15 years, by all measures. Yeah, so thank you very much for just bringing us home also into the operations of the Office of the Attorney General and the good work that you're doing. And please keep it up. And as you said, we unite and do this together. Don't we have a role as well? As I said, as CSS, we do have a role, don't we, as a profession? Yeah. So let's play our part. Let it be, reciprocal. As they do their part, we also do ours. So we also called upon to stand up and be bastions, of good governance and also just ensuring the rule of law is upheld. It starts with us. So thank you once again. I would like to appreciate you with a token. FCS Patrick Mulwa, may I please have you come to the front? That is also the CEO of the Registration of Certified Public Secretaries Board. For those, he's the one who gives a tick and says, you may practice. So please, it's a man you need to know. But know him only professionally, please. All right, yeah, so. Yes, please present CS Murori Ngugi with a token of appreciation. Let's say thank you.